We can start.
Yeah, good morning, everyone. Uh, so I've got the opportunity today to present on this topic of OIDAR vis-a-vis import of services. So what is the difference or what is the distinction we can draw between online information database access and retrieval services and import of services? Generally, both are provided by a supplier outside India, and there is definitely a big scope for confusion whether it is a OIDR services or import of services. We need to distinguish this because in case of OIDAR, also reverse charge is applicable, and even in case of import. But if the receiver is not registered, or I would say he is not taxable, uh, then the GST on the OIDAR is to be paid by the supplier itself. So that is the reason there needs to be a distinction between the two. If it is import, the supplier will not have to pay it. But in case of OIDR, the supplier will have to pay. That is the reason there needs to be a distinction, because for OIDR, we have a special provision where the recipient is not registered, then the supplier has to pay. So that is the reason we are deliberating this topic today. We'll go with the basic definitions, understand what is OIDR services, what is import of services, and then see what are the various taxing ingredients, take some examples, and then take some case studies to, understand this in a more better manner with some practical cases which we will see. So definition of OIDAR is given in the IGST Act. In section 2, subsection 17, it states that online information data and database access or retrieval services means any services whose delivery is mediated by information technology over the internet or an electronic network, and the nature of which renders their supply impossible to ensure in the absence of information technology, and includes electronic services such as. So there is a list of services. We'll not go to that list. We'll understand the definition, the basic crux over here itself. It says any services whose delivery is mediated by the information technology over the internet. And the amendment which happened in 2023 was that earlier the terms essentially automated and involving minimal human intervention was there. Now that aspect is deleted. So now it may be automated or not, and human intervention is deleted. So even if a minute or minimum human intervention is involved, then it will not be falling under the OIDR services. So then presently after this amendment, how do we read this definition is that any service whose delivery is mediated through internet, through the information technology over the internet, and where it is impossible to ensure in the absence of information technology, that will be treated as a wider services. And there are certain definitions which have been given, or certain examples which have been given, they are specifically included. So this is the definition of wider services. Now when we understand the definition of import of services, import of services is again given under the IGST law. Under section 2, subsection 11 of the IGST Act, it says that import of services means the supply of any service where the supplier of the service is located outside India and the recipient of service is located in India and the place of supply of service is in India. So this is more of a broader definition wherein they have not specified what is the nature of service. They've said that any service, the supplier, if the location of the supplier and receiver is decided and place of supply is decided, then that tantamounts to import of service. The supplier has to be outside India, receiver has to be in India, and the place of supply should be in India. That will tantamount to import of service. So we can say that OIDER service also, they have defined it separately, but there is a specific place of supply for the OIDER services where the place of supply is in India if the receiver is in India. So in that aspect, import of service is a broader set, and OIDER becomes one of the subsets of import of service. But for OIDER services, the government realized that there will be a lot of consumption which is happening in India, and the consumption will be happening by a non-registered person. So there will be a lot of revenue in terms of this digital tax. So in India, it is called as OIDER. In some other countries, it is called as digital tax, wherein any digital transaction which is taking place and the consumption of that happens in the respective countries. In that situation, the receiving country or the consumption country wants to tax it because the supplier will be outside India. He may not be paying the tax, but they are deriving benefit from the utilization of that in a particular region. So then all the countries would like to want to tax it. That's the reason OIDER is being taxed in India, because the consumption happens in India. So, with that understanding of the basic definition, what is the differentiation between these two is in terms of place of supply. 1312 says for OIDER services, the place of supply will be the location of recipient of services. That will be so whenever the receiver, the place of supply is the location of recipient, we will always think that yes, it is liable to reverse charge. That is true when we read section 13. But for OIDER services, there is a special section, section 14, which says that if the supplier is located in a non-taxable territory and the recipient is a NTOR, which means he is a non-taxable online recipient, okay, then the supplier shall be liable to pay the tax on that transaction. So the supplier shall be liable to pay tax provided the recipient is a non-taxable online recipient. The definition of non-taxable online recipient is also defined. We'll go through that. But we have to understand that even though the location of recipient is in India and the place of supply is in India, but the tax will be paid by the supplier if the recipient is a non-taxable online recipient. So that is the place of supply for OIDER services. But in case of import of services, we'll have to go to the general provision of place of supply, that is section 13(2), which says that the place of supply for import of services shall be the location of recipient of services. So if a supplier is outside India and the recipient is in India, the place of supply will be India because the recipient is in India. And by virtue of section 7 on import of services, tax is payable, and if it falls under the reverse charge definitions, and which is falling, all the import of services will be falling under the reverse charge by virtue of notification number 10 of the IGST Act. So on all import of services, the recipient will have to pay the tax. Now, there are questions which we'll discuss later on. Should the recipient be registered or should the recipient be unregistered in case of import of services? We'll have a separate slide and we'll discuss that time. And we'll understand whether a recipient who is, because in the definition, in the notification of reverse charge, notification number 10, some places it mentions in case of recipient only, in some places it mentions a registered person. So for this, we will have to see whether they have used the term registered recipient or just recipient. The going through the section 1312, the place of supply says that place of supply of OIDER services is the location of recipient. Then it says that there is an explanation which is added, which says that the explanation to this subsection 12 lays down 7 conditions, and it says that on satisfying any 2 out of the 7 non-contrary conditions, the service recipient is deemed to be located in the taxable territory. So when it becomes uncertain or it becomes unclear to determine if the recipient is in India or no, or whether he is located in a taxable territory or not. So the section itself lays down 7 conditions. And if you're satisfying any two, or the recipient condition satisfies any 2 out of these 7 conditions, then the recipient will be deemed to be located in the taxable territory. Irrespective of his actual location, he may be located elsewhere when he is consuming the service, but the section lays down artificial conditions, artificial criteria, and says that even if 2 of these 7 conditions are satisfied, then the recipient will be deemed to be located in the taxable territory. Now, these 7 conditions are: first is the recipient gives an Indian address through the internet. So when he logs in to the service, say he's logged into Ghana.com and he's given this Indian address. So then first criteria is satisfied. The recipient has given his Indian address. Second is the payment is settled by a Indian credit card or a debit card which is issued by a Indian company. So the payment is settled by a Indian credit card or a Indian debit card. So any transaction which is making through the card purchase, that card payment is settled by the Indian card. Third criteria is the recipient has an Indian billing address. Okay. So when the recipient gives his address, he gives the Indian billing address, then the third criteria will get satisfied. Fourth is the address criteria is not here, but the device or the computer which he uses has an Indian IP address, which means he is actually located in India and is given the IP address belongs to the Indian region. Next criteria is the recipient uses an Indian bank account for payment. So if the payment is not made through the card, it is directly made from the bank account, and that bank is a Indian bank, then fifth criteria will get satisfied. And next criteria is the country code of the subscriber identity module card. So when the payment happens through this subscriber identity module card, which is used by a recipient of services, and the recipient is a Indian. So then this criteria will get satisfied. And the last criteria is the recipient receives the service through an Indian fixed landline. So when the recipient uses a fixed landline to avail the services and the service is through an Indian fixed landline, then it is clear that it is a location is India. So not only one condition, minimum of 2 conditions has to get satisfied, then the recipient will be treated as a recipient is in India. So, how do you determine this? Is a very challenging question, that who will determine this? So basically, OIDR, when he is providing the services, he will have to decide whether how much of information of this he is able to gather, because the onus of this will be on the OIDR service provider itself, because he will have to decide whether this any of these 2 conditions are satisfied. He will have few information with him. He will have the address of the recipient. He will have to track the IP address through which the services are being received, are being consumed, and he will have to then also see the mode of payment. How is the payment made and through which card the payment has been made. So if he is able to satisfy that, yes, 2 out of these 7 conditions are satisfied, then it will be liable in India. If any of these 2 conditions are not satisfied, or even one condition is satisfied, then it will be treated that the recipient is not in India and it will not be taxable, because the supplier has to be outside India and the recipient has to be in India. If the recipient is not in India, which will mean that the place of supply is not in India, and then it will not be taxable in India. Now we are discussing also on the definition of non-taxable online recipient, because We said that when the supplier is outside India and the recipient is a non-taxable online recipient, then the tax has to be paid by the order provider itself. It should be paid by the service provider itself. So, what is this non-taxable online recipient? NTOR means any unregistered person who is receiving online information and database access or retrieval services located in a taxable territory. So, very simple, wherein they've said that any unregistered person who is receiving order services and who is located in the taxable territory, he is a non taxable online recipient. Earlier, this definition was different, but in budget 2023, this has been amended. We will understand what is the implication of it, because prior to this budget amendment, the mentioning or the definition read that any central government, state government, or any individual who is receiving the services for non-commercial purposes will be treated as a non-taxable online recipient. So how do you determine when the individual is using it for his commercial purposes or non-commercial purposes? That was the issue. So then in 2023, this got amended, and NTOR is very simple now. When any unregistered person receives the OIDR services and who is located in a taxable territory, he is treated as a NTOR. Whether he uses for commercial purpose or non-commercial purpose, doesn't matter. He is unregistered, the supplier has to pay. Okay. And for the purpose of NTOR, any the inclusion of unregistered person says that the expression unregistered person will also mean a person who is registered under 24/6, the person who is the government, which is supposed to register for the purpose of TDS, they will still be treated as a unregistered person, because only for the purpose of TDS deduction they are getting registered. Now, services, OIDR specifically, when we say services should be provided through the internet, and the nature of which renders their supply impossible to ensure in the absence of information technology. So, any OIDR services will be treated as such when any normal service, if it is provided through the internet and which cannot be accessed, or the nature of which renders the supply impossible to ensure in the absence of information technology. So any services which is provided offline will be different. And if that service is always provided on the internet, or when it can be consumed or it can be utilized by the recipient when the internet is available, that will be treated as a OIDR services. Examples is online advertisement, because when you log in through a web page and you see a advertisement, it is available only when you have the internet on the on mode. If the internet is not available, you can't go to the web page itself. So that's why online advertisement is one such example. Cloud services, all the cloud storage services is available when you are on the internet. Next is ebooks. Now, ebooks also could be of two variants. One is you are getting the access to the ebooks. You can download it and read it later on. Like a Kindle, you have a Kindle device, you can download the book and read it later on without the internet. So that will not be treated as a order services, but a ebook which is available only when you are using the internet, that will be treated as ebook. That will be treated as a ebook, which is a order services. Then music streaming, like various music streaming apps are available, wherein if you are on the on internet on mode, of course you can download it, but that will be there in the cache, so that will still be treated as a order services. But distinguish this with such services wherein you can download it and play it later on. So such services which are downloadable and can be used later on, I would not treat them as order services, because the important condition of order is it should be usable when you have the internet on mode. Only such services will be treated as order services. If you can download it and use it later on, then it will not be treated as a order services. Similarly, online gaming, most of the games are now available only when you are online. So there are certain games which you can download and play it without internet. They will not be treated as a OIDR services. Taxability, we have discussed this, taxed under IGST when supplied by a foreign service provider to a unregistered person in India. It'll be, I mean, in both the cases, it will be taxable when it is supplied to an unregistered person or supplied to a registered person. The difference is when a registered person uses it or when a registered person downloads it, he will be liable for paying it under reverse charge. But in case of a unregistered person, the tax will be payable by the supplier. Yes, Venu sir.
Deepak, so here you are saying if the someone downloads the game and plays offline, it would not be OIDR, is it?
Correct.
But for before he download, let's say he has to subscribe and subscribe to that and download. So the payment is made online. So that would still not be OIDR, is it?
Yeah. So if you contrast this with Tally, for downloading the Tally software, I have to log in and only
Right.
then I can use the service.
Right.
So similarly, Tally, I will not treat it as OIDR services. So similarly, any games which I have to subscribe and then log in, still it will not be OIDR services.
Subscribe and login. So even if I play games online, it would not be OIDR?
If the game is in such a way that you have to be online and only then play it. If you're offline, you cannot play it. Then it is OIDR services.
Okay. So the internet being available at that point, you are saying.
Correct.
See, today most subscriptions are like works both online and offline mode. Like for example, we have this these pen drive classes where students take. Now the media player gets downloaded. The media also gets downloaded. Students doesn't need internet when they're looking at those recorded classes. But every time before start or after start, it gets connected to internet and checks their subscription is alive, and it stops playing if the subscription is off.
Okay.
So strictly, I don't know whether we have to say whether it is online, partially online, partially offline. When the service is being consumed, user doesn't need to be online, but it got to be, the application has an online thing. Otherwise, it will not work. Even those games people are say by downloading anything, which is all let's say time based. After the certain time, it will not work unless they go back to online and renew their subscription.
So when such conditions are there that you need to go back and subscribe it or go to the internet. So then what it is trying to do is it is making the game impossible to play unless you connect it. Right. So might be there is some time gap between being offline and being online. Right. Still, then this will be treated as OIDR because it is trying to say that you're making the application impossible to play in the absence of information technology, right? But when you can download it and you don't have to go to the internet again, then you can play it being offline also. So mode of delivery is IT, but usage of it is not dependent on the IT.
It is dependent on IT, but not dependent on internet.
Not dependent on internet. Okay. So there is a difference between IT and internet is what you're trying to say. Okay. So internet is the mode for delivery and IT, if it is impossible to pay in absence of IT, then only it will be OIDAR.
So it is information technology rendered only once over internet, but internet is not required. So I still feel that there is a very thin line to say that excluding those transactions.
So why I'm coming to this conclusion is the definition says that whose delivery is mediated by IT over the internet and the nature of service, nature of which renders their supply impossible to ensure in the absence of information technology.
Can you also just show the definition on screen once?
I think we need to differentiate between delivery of service and consumption of service. It talks about delivery, not consumption.
So it starts with delivery. So it says that whose delivery is mediated by the information technology over the internet or an electronic network and the nature of the service. So they are distinguished two parts. One is delivery and the nature. The second part says that the nature of which renders their supply impossible to ensure in the absence of information technology.
But information technology need not be internet connection, right? It need not be online. Once you have got the subscription through online mode, it is up to you how you use it. You use 1 time, 2 times, 10 times, 100 times. That becomes secondary.
So what is then the meaning of information technology without internet?
It's a usage of IT products, IT hardware, software, which are all enablers to use those services which I have subscribed.
Okay. So you're saying if I download it through an app on my mobile, so that mobile also becomes the information technology.
Yes, yes. The example Venu sir said, no, once the student gets the authorization or permission to use those lectures, how much overtime he wants. For that, he doesn't need internet. He just need every time, as he said, his subscription, whether it is active, inactive, expired, all that need to be checked. If he's active, he'll be allowed to use offline.
Okay.
So I agree with what Venu sir said. You need not have internet all the time to consume the service. Consumption can be, without internet also.
Okay.
Deepak sir, why don't you see the IT Act, Information Technology Act 2000, wherein they have defined the terms of information technology, then electronic network. I think they're defined there. So probably if you look into the IT Act, maybe that will help us. That should resolve your queries. I don't know if you have any slide on the definitions in the IT Act.
No, I have not included that, yes.
No, I think probably there, because what is information technology is not defined here. What is
Correct.
electronic network is not defined here. So I think we need to essentially go back, at least in Indian context, we need to go back to the IT Act. And probably there you have to look into, then I think all the answers we will find, whatever we're discussing now.
Yeah, maybe I think one more on this aspect, one research is required, Deepak.
Sure.
Yeah, please continue.
Okay. So continuing from where we stopped, online advertising, we discussed on the examples and taxability. So if the supplier, the recipient is registered, he pays the reverse charge. Otherwise, the supplier pays it if the recipient is unregistered. Various examples are AI driven advisory services, something like advisory services, which is not provided by human. You ask the question online and the information is not dependent on any human intervention. Whatever is the information or the data available, based on that, AI captures the information and provides answers. So such advisory is one example. Then any SaaS platforms where you are only using the services online, when the services are provided online, software as a service, and there is no human intervention. And live streaming services are any streaming services wherein the data is available, and say like a movie streaming, the movie rights are there with the distributor. He he give he gets the say there are various rights for a distributor. He gets a right to streaming rights or these OTT rights. Now the service provider acquires that rights and he streams it. So such services wherein the consumer is in India, supplier can be that he can be outside India, he's got the right to stream it, he will stream it, and the receiver is consuming it. That service also is a good example of order services. Now, when we understand the import of services, in case of import, services which is received from a foreign supplier for business or personal use. Here, we don't have to see whether it is for uh, only business use, because even personal use will be liable. The conditions for import says that the supplier is located outside India, recipient is located in India, and the place of supply is in India. Then it is a service which is liable to GST, because import of services, when we see under the definition under section 7, import of services when there is a consideration and the condition of whether used for business or not is not there. So when you use any import of services even for personal use, it is liable. Now to pay the tax on that, you have taxability under the reverse charge under section under 10. I will take you through notification number 10, which says any service which is supplied by any person who is located in a non-taxable territory to any person other than a non-taxable online recipient, and that is the category of a service which is liable for reverse charge. Supplier of service will be any person who is located in a non-taxable territory, and recipient of service should be any person who is located in the taxable territory other than non-taxable online recipient. So in case of import of services, it says that who is the person who is liable to pay tax? Any person located in the taxable territory. So what does this mean? That if the recipient, whether he is registered or unregistered, that doesn't matter. If the recipient is a person who is located in the taxable territory, he is liable to pay tax. The impact of this is that we will have to see if you are consuming any service. Now, uh, the recipient is not registered, he is availing some services. Now, should he pay taxes on that? If he is registered, definitely he has to pay. If he is unregistered, should he pay? I think he should pay, because any person located in the taxable territory, so the liability is there on him. And under section 24, it says that any person who has to pay reverse charge will have to register and pay. So in such scenario, the liability is on the recipient to pay the taxes. If he is unregistered, then he will have to register and pay. Because notification 10, what we have seen, uses the term any person located in the taxable territory. It doesn't restrict to a registered person. Any thoughts on this?
Can we look at some examples of services which are import of services but not OIDAR?
Yeah, so anything other than OIDAR will become import of services. A good example would be that when you are constructing your house in India and there is a architect. Now, architect is a foreigner who is providing you the services of the design and blueprint and other things. This will be treated as import of service because the place of supply is in India. That's the place where the immovable property is located. So in such scenario, what will be your liability to pay tax?
This could be a rare scenario. What could be common scenarios where there is import but not OIDAR?
In businesses, we use a lot of consultancy services when the consultant is outside India and he's
So then that
providing
person
services.
is a business person. So anyway, he would be registered.
No, but
I'm
he's
thinking,
not in India.
no, business in India taking consulting from outside India would ideally be registered, or it's
Yeah.
okay. They will not mind to be registered. I'm thinking of what could be individual services where typically the person receiving service would not be registered and services and is importing.
Let's take this example itself when a person is not registered, because we're not trying to see the examples, we're trying to see whether there will be taxability on the recipient or no. So from that perspective, if there is a person, he's a business person, but his not cross the threshold limit and he's not registered, and he's taking consultancy services from a consultant outside India.
So there, I feel like the business will not mind registering. I'm looking at what could be cases where, the individual or whatever is not registered. He'll be taking some services from outside India, but not aware that he needs to register, and that's where we come in, right? Uh, Saying, you know what, this is an import of service, you need to register. For businesses, it is easier to convince
Got it.
because they'll get the credit.
That's correct.
Does every import mandates you to register?
Yes, no, I think 6 and 24 mandates.
So if that being the case, if you are availing some foreign consultancy services for taking a decision of which college to join, you are making some payments to them online. Will that make you to register? It's an import of service. So it's only in the course of business is something we need to see.
For import of service, course of business is not required.
So now all the foreign payments that you are procuring, let's say you have returned from abroad, and you have some returns, some IT returns to be filed. So you will look at some website like Clear Tax Equivalent, HNR block. You submit the data there. They file the returns.
That will become import, no? If it is not OIDAR, if it is not done by using technology, information technology, etc.
Yeah, you are
That will be
uploading the
import
data
of
there.
service.
They are filing the returns.
Yes.
So does it make you that you are a salaried employee? That is, will that make you to register and pay RC?
Ideally, if it is not OIDAR, like if it's not done, if the filing is not done using information technology, all of that, then I think yes, the recipient has to register and pay tax under RCM and won't
Yeah,
even
so
get credit, nothing.
there are a lot of people. If you see the US return and everything, they connect to some CPS and do that. They pay over the internet. They submit the documents or email, and they file it. That way,
Yeah.
these things definitely doesn't get tracked, and how will you
Tracked, yeah.
enforce the law? These people, only for the purpose of this, they register, they close the pay GST and close.
But how government is monitoring all these transactions? Is there any mechanism through which they just check how IP address and all that? Is there any back-end verification process happening at a larger level?
You want to set up, let's say, an office in Singapore. You will still take consultation of a CPA there. You will be transferring the money over the thing.
But are they sending notices?
That's a larger picture. I'm not sure anyone in the group are equipped to answer that.
So, setting up an office in Singapore, taking a consultant's help in Singapore, I think there is some case in service tax which says that the place of supply becomes Singapore and not India. So I think there we'll have to check whether the place of supply is India or Singapore, for instance. We'll have to delve into that.
Place of supply is still in India. You haven't set up anything. You're only taking consultation.
But the consultation is to set up an office in Singapore.
Yeah, towards you may have to get DIN, you may have to do whatever. At one point you might have to travel, but eventually it will happen, not happen. But still the place of supply is not Singapore, it is India. For them it is export. In their returns, they will treat this as like in our returns. If someone wants to get an advice of what is DIN, how to incorporate company, how to take GST, they are taking consultancy. We are giving them consultancy. They're paying us in dollars. For sure, I am going to treat this as an export of service in my returns. I'm not going to treat place of supply as India and pay GST on this transaction.
We'll have to delve into this. I think there are certain service tax case laws for
No,
both.
no. See, 1 minute. See, we are mixing up place of provision of services and place of supply. Place of provision of services is all gone. This is place of supply. We strictly have to look at what is the law in GST.
Right. Yes.
Eventually, the Indian company may aggregate all these expenses and they may cross-charge it to the subsidiary once it is incorporated and so on as preliminary expenses. But what happened? We went from OIDR to we are all over the place.
We started with the OIDR. Now we are on to import of services.
Okay.
So if we,
Okay, so place of supply and place of provision of services, we have to be careful.
Right, sir. So, sir, we are thinking of examples where they are import of services and not OIDR, where the recipient is compelled to register in India and pay
If
the
it is
taxes.
not business, nobody is compelled to register. Even though import of services does not require business, 10/17 IGST says if it is personal, there is no need to register and pay tax. All your B2C transactions where people in India are making remittances under LERMS, nobody takes registration. Why are we wasting time on that topic?
Sir, what is LERMS?
Liberalized Exchange Risk Management Scheme allows $250,000 of no questions asked outward remittances. On that, there's 20% TCS. Only to explain that we have accounted revenue income that we have used to make these remittances. There's a TCS which comes back as a refund. Nobody takes registration. Nobody pays any RCM on that. It's only B2B that registration is taken and credit is availed if applicable. And all this is all very, very basic. We're just reading the section early in the morning. I'll
I'll go to
after 8 years, you're teaching us the section. If you don't know the section, then you should not be wasting your time with full stackers. But if you think we know the section, then you must raise the bar and tell me issues that has to be discussed. What is import? What is OIDR? What is OTT? What is technology? What is information? Yenapa. Below CA foundation, BCom level, you're taking class. You must respect that participants are all speakers themselves in various forums. They publish papers. Raise the bar. Let's look at issues. Forget notification, forget circular. If you show any advanced thing, I'll kill you. Something else you show. What are the issues? If it's not on your slide, forget your slide. Raise 5 issues. Let's have some meaningful conversation.
Yes, I'll go to the issues directly then.
I'll give an issue. We'll start with this. Import of plans, designs, drawings, architectural plans, designs, drawings is import of goods. There's a tariff classification in chapter 49 in customs tariff. Now, is this import of goods or import of services? Because it is not specified in schedule 2. Tell me.
Import of plant designs.
Plans, designs, and drawings. Architectural plans, designs, and drawings. There is a customs tariff classification. As you know, in GST tariff, we have to, for goods, we have to rely on customs tariff.
Right.
Now, when I import, let us say 500 kgs of plans, designs, and drawings, I'll file a bill of entry and I will get it assessed to customs. Is this import of goods or import of services? How will I treat this if it is import of services? Will I pay customs duty as well as GST as import of services? Ilandra, we will park this and we'll take some other issue. We'll take issues and discuss. Section 3 columns, RSM notification, adilla beda. Everyone has books in the hand. No issues listed. Then you open the floor. We'll see if anyone has issues that they want to bring up for discussion.
Deepak, I have posted a question.
Tell me, madam, what is the question? Ask everyone so everyone thinks about it. And Deepak will answer.
Deepak, basically the medical transcription services are directly taken by the consultant. So there is a doctor, I'm just briefing you the background. There is a doctor sitting in US, okay? He records and sends the whatever conversation that he has with the patient. Okay, so that is sent to the consultant of a company in India. Okay, so what he does, the over voice over IP, it comes to the consultant. The consultant processes, validates, translates, and sends it to the company, XYZ company in India. Okay, then the XYZ company, which is authorized person, which has entered into contract with the consultant, it authorizes and sends the bill to the doctor. It basically export of services. So as a consultant, does he need to take care of anything? Will it fall under OIDR or import of services? Or company only should pay, import of services?
So the consultant, if I can understand the facts clearly, US doctor records the patient's history, right? And he sends the data to the consultant in India.
Correct.
Okay. And this consultant uses that data. And what does he do with this?
He transcribes, he translates into English. The data
Okay.
comes in different languages, say in Germany or in any other language.
Hmm.
In
And this consultant uses the data from the doctor. He converts it and he sends it to some company. Okay. And this company again authorizes the consultant to provide the kind of give the data to the company, right? The company uses all of this information.
See, in simple terms, it's just like medical test is done by somebody who's authorized by Apollo. He comes, collects the data samples, and then he only does it in his lab and gives the report to Apollo. Ultimately, the report will come in the letterhead of Apollo. The same scenario, if you map it to some other country, what is the legality or any taxability for the consultant sitting in India? He's also rendering business. He's also availing services from abroad. So just because it comes over internet, will it be like, OIDAR? And since he's not a registered person, but just because he's doing business, so he necessarily has to take registration and pay tax under import of services, or what is it?
Madam, here you are the one who is providing service. No, it is you are exporting the service, right? Are you asking that for US will it be OIDR?
Sorry?
No, you are providing service to a US doctor.
Company is providing.
Yeah, Indian company is providing a service to the US doctor, right?
Correct.
So are you asking from the US perspective, will US treat this as OIDR? Is that the question?
So who has to pay tax? The consultant, should he pay tax or he need not pay tax is my question.
No, where is the import here? You are earning foreign currency. You are not spending
No, the
foreign currency.
consultant is getting data, no. The consultant is getting data through internet.
Okay. Indian entity is getting data through internet, and Indian entity is providing transcription, and for which they are earning some forex.
Correct. He's rendering services to another company.
Correct. So where is the question of import here? It is an export, right?
He's getting data from the doctor, no.
He is getting the data, madam. After processing the data, I am getting the money.
Correct. It is export of services done by somebody else. Another level of validation happens, and that company only, private limited company, is rendering export of services to US doctor.
So are you asking, will US treat this as OIDR? Is your question?
Will it fall under, for a consultant, will it be an import of services is my question.
Is there a consideration, madam?
No consideration. Consideration is not flowing from the foreign doctor. The contract for the consultant is only between the Indian company and the Indian consultant. That's all.
Indian company, instead of
services.
hiring an employee, they have hired a consultant to do this job, correct?
That contract part is missing. See, ideally he's a, agent of that company, right? How will the doctor will send it suddenly to some unknown person? But there is no contract with the consultant and the doctor. But he sends it. He sends to his email ID, everything comes to him only. So how to protect the consultant? How should he protect himself tomorrow from getting any notice from department saying, okay, you have availed services from abroad? That's my question. He's rendering services to Indian company for which he's charging GST. This is separate. That's fine.
Madam, for import also, 7 says that even if it is for business or not business, there has to be a consideration. But in your example, in the facts, what you have said, there is no consideration. So there is no import of services per se.
Okay.
I am of the same view.
So there is no import of services. So what is the status for that foreign company, foreign doctor?
See, the contract for the foreign doctor is with the Indian company. They wouldn't care, the foreign doctor wouldn't care whether consultant A or consultant B is doing. If something goes wrong, the legal enforcement is with the Indian company. Isn't it?
No. What about his taxability when he is rendering, like, sending data to India, right?
Madam, even that Indian consultant who is doing, he is acting on behalf of the principal. He is not doing a principal to principal services. He is given instructions that you will get the file from a doctor in US, you should do this work and you should send it back. But he is still acting as an agent. Tomorrow this company can send the data to consultant A, consultant B, consultant C. So consultant in India is purely providing services to Indian company.
The data is flowing from US.
Of course.
See, when it is a goods, we are talking about Trump tariff, all this. So when
No, even in the goods case, madam, if let's say you are the importer on record, but on your instruction, the goods can come to me directly. It's not necessary that the importer only has to go and bill of entry would be filed by you. But from the port location, the goods will directly move to me. That doesn't make me as an importer on record.
okay.
Like export also, goods might move from my location, but you will be the person who will be filing the shipping bill. Same goes with the goods and services also, isn't it?
Anybody has any different views, or I can take that as a final answer?
Are you convinced? That is first thing.
I don't know. I'm still have a doubt.
Okay.
I too agree with Venusa's view.
Deepak sir.
So that's I've said it's not import of service. Anybody else who's giving a contrary view?
You are saying it is not import of service, right?
Right, not import of service.
But
Yeah.
somewhere,
Because for you, consider
tax. If it is escaping import of services, then OIDR, can he take it that way? No, in any transaction.
madam, before that, Deepak, you are saying it is not import of service because there is no consideration. Is that the thing?
Correct. Yes.
But primarily, is a contract at all there from the US doctor with the Indian consultant?
See, that is where the problem is. That if it is a contract, then we can properly discuss. There is no contract. Likewise, there could be so many transactions which are escaping tax, right? So if that being the case, how is the government tracking?
Madam, we can't say escaping tax unless we establish that there is a tax.
See, when we are paying for a small Google Gmail or website, domain charges, all that taxes are getting paid, right?
No. In this case, first let's establish that there is a tax liability. Like Deepak is saying that since consideration is missing, there is no tax liability. I am saying that privity to contract itself is missing. He is not even a party to it.
Maybe they are treating it as two individuals, so that's why there is no contract. And I mean, that's what, there is some lacuna in the contract, that the way how they have designed.
Madam, it's not about individuals. Like you can look at a machine sold by Cisco, Dell, or anyone. Let's say an image processing machine, which is sold to a hospital. Now, Dell is not the one who is going to come and service that machine. They will be appointing an agent. It's again a private limited company, some authorized persons who can come and touch those machines, right? And in this case, the contract is still with the party A, party B. It is no way hospital will say that the consultant who is doing, he is putting a case on them. It would be the responsibility of the Dell who provided the service warranty to take care of it.
So you're saying there is no kind of a transaction, or there is some exchange of information, but without a contract.
The contract between the US doctor and the Indian consultant is missing, right? And there is a cost involved that is being loaded onto the company, like, medical transcription company is rendering services. There is a contract between the company and the doctor. So export of services. So my question is, there is some element missing here, or is it, I am assuming that there is something missing?
So, Venu sir, what you're trying to say is there is no kind of a agreement between these two people, so it is not taxable.
Yeah.
Okay, so that's fine. See, that's how it is going. No contract, nothing. So it is not taxable. But ideally, if there had been an agreement, then this person also, Indian consultant also, will go for registration, right? He will go for registration. So he is taking services from abroad, rendering to an Indian company, because this consultant's advice or report, the doctors will not take. It has to be from a formal company. So he cannot render export of services. Ideally, he has to go give it to the Indian company.
Madam, look at this way. If the Indian company doesn't pay, will this person go to the US doctor and sue him for the money?
No, nothing.
Nothing, right? Now, when you can't even enforce your consideration, how can you say that there is a contract? How can you say that there is a service? Like, see, if the service is there, you should also have a right to receive your consideration. When you yourself are clearly saying that you cannot do anything with the US doctor, where is the question of contract supply? I'm going on the road, there is a barricade, I have lifted and I placed it outside. Doesn't mean that I'm making a supply to BBMP, right?
No, see, it is not that way. Probably we can take it offline. I don't want.
No, I want you to bring the ingredients of the contract also, madam.
The problem is that assuming if it is done by an Indian company instead of that medical transcription private limited company.
My answer is the same. Whether it is an individual consultant or a company who is doing this work, and company A has outsourced this job to company B. Instead of consultant, it is a company B. How does it change?
No, are they not getting the data from abroad? Assuming there are two companies are involved.
Data is coming from abroad, madam. The job of company B is to process the data which is being received into their inbox from some US hospital and after doing their job is to send to US hospital.
So
Still, they're not even, let's say they're not even giving to company A in India, who is the contractor.
okay, if they are giving it to some XYZ instead of giving it to the same person,
No problem. Still, how does it matter?
if a company getting the data from US, processing it, and then selling it to some other company.
No. Selling is different from sending.
Selling only, say I'm not talking about sending, I am talking about selling only. So export of services, when you are doing export of services, what happens to the data?
Now you are changing the examples in the contract. Originally, you said company A has received this contract. They have given to company B. Company B.
A has that is what I'm saying. Please let me explain you the case once again. Consultant A, without, see, I am Sujata. Okay, suddenly in my email I am getting a mail from a doctor saying in a attached PDF in a recorded voice. Okay, saying this is the data you have to process. I don't have a contract. Nothing I have. What I do the processing. Send it to Apollo. Okay, send it to Apollo. Because why I am sending it to Apollo? I have a contract with Apollo, right? So I am invoicing CGST, SGST, and they are also happily paying me.
No,
Now,
firstly, why did you process? Why did you process the data?
Because it has come to me. There is a contract between me and Apollo. They are
No,
saying,
so you processed because Apollo has asked you to do.
no, Apollo has not asked me to do. That is a problem. Apollo has only one contract. Sujata will give the data. I will validate it and export. That's all. So with me, but
I don't know. I am getting confused with the facts, madam. Every time some new
no,
dimension
that is
coming.
what again, that is what I'm saying. The contract part is missing. Ideally,
Madam, what I can understand from your, just try to put it is, there is no written contract, but any information what is flowing is because of the oral contract. Otherwise, no doctor will send you any information without you having confidence on you. Okay. So you don't have a written contract, but you have a oral contract.
correct.
Right. So there is a agreement, not a written agreement. Oral agreement is still available. So based on some terms which you have understood, data is being flown to you. Based on that data, you are doing something and selling that data.
Correct.
So I will still stick on saying that agreement is there, not a written agreement, oral agreement, but since there is no consideration, there is no taxability.
Okay.
But why will anybody do anything for free in business?
See, I am getting, why I am not doing it for free. I am getting it from my local doctor, no, local Apollo. So
See, then is it like services provided to somebody and recipient in terms of who pays the consideration is somebody?
these are all not written. Actually, that's how it is happening.
No,
Madam,
because see,
business
or there
like,
should be some indirect benefit flowing because of providing this to Apollo. Otherwise, why will some or whatever export, whatever you're saying, but otherwise, why will somebody do something without money in business or some other benefit which it is not flowing directly in terms of money, but some other benefit?
But these transactions are not getting noticed, happily happening. No problem.
Madam, no business will do without any contractual terms, madam. It's like we are talking a very hypothetical.
No, see, individuals, because I am also an individual, doctor sitting in US also individual.
Correct, madam. So you will not work unless you have a contract with Apollo or saying Apollo, I will pay you.
Deepak, you take one by one issues. We'll just park the question.
Fine. See, first issue is this is related to law itself. It says that import of services is defined under the IGST law. What could be the reason that import of services is defined, but it is not used anywhere in the law? So why is the definition itself there? So these are the few issues or few questions which we and Siddesh were discussing. So he said, why is the definition of import of services itself there in the law when they have not used it? So then I found that this could be the probable reason that import of service is not used anywhere in the place of supply provisions, but it is defined under section 7, when it says that on import of services with consideration is liable. So to give the meaning to import of services, what is there in section 7 followed with schedule 1, to define that they have defined under the IGST law. Then the second question was, why haven't they defined this under the CGST law? Because Constitution gave power to decide what is interstate to the Parliament. So only the IGST law only can define. That is the reason import of services is there under the IGST law, not under the CGST law. The definition per se is defined under the IGST law, not under the CGST law then.
Deepak, what difference that would make if it would have been defined in CGST law also?
No, if it is there under the CGST law, then it means then that will be under the state law also. And the state will not have power to define what is an interstate transaction.
Correct. So, isn't it rightly placed being in the IGST Act?
Correct. I'm only saying why it is there under IGST Act.
Okay, got it. But from the levy perspective, isn't it notification 10 is targeting these entries?
Levy is still there under section 7 itself, sir, because import of services is still there under 7 itself.
No, that's what I'm saying. You said that it is nowhere used.
Correct.
Or you are saying nowhere used only under IGST Act? That's the
nowhere
only...
used under IGST Act.
Okay,
Yes.
okay, done.
The second issue is section 14. We'll go through section 14 to understand, because we'll have to go through this. Okay, section 14, only the proviso part, because 14 subsection 1 says that when a OIDR service is provided by a person in a non-taxable territory to a non-taxable online recipient, then the supplier is liable to pay the tax. Then the proviso says that in case of supply of OIDR services by any person located in a non-taxable territory and it is received by a non-taxable online recipient who is an intermediary located in the non-taxable territory, who is arranging or facilitating the supply of such services, shall be deemed to be the recipient. So the intermediary is deemed to be the recipient of such service from the supplier and supplying such services. So the proviso is defining who is an intermediary, and it is saying that intermediary shall be deemed to be a recipient. So the question here, what I'm trying to raise is that since the intermediary, on satisfying some conditions, he is becoming a recipient. But everywhere I'm seeing that if there is an intermediary, the taxability shifts to the intermediary. I am not able to comprehend from where does this conclusion come, because 14 says if the supplier is in a non-taxable territory and the recipient is a NTOR, the supplier shall pay the tax. Now, through this provision, the Act is trying to say that this intermediary is a recipient. So the tax will still be payable by the supplier itself. So how is the intermediary made taxable in this scenario?
Deepak, proviso is B2B. Subsection 1 is B2C.
Right, but B2B, and he is a intermediate in a non-taxable territory. Supplier is also in non-taxable territory, and intermediary is also in a non-taxable territory. So I feel I did not get any answer for this. I found that this provision is probably not worded correctly. So even if there is an intermediary who is involved, the liability will still be on the supplier of OIDR service itself. Had it been that intermediary is introduced here and he shall be deemed to be the supplier, then the tax will be on the supplier, because 14 says the OIDR services provided by a non-taxable supplier, then the supplier of service shall be the person liable to pay. But the proviso is saying that the intermediary shall be a recipient. So the liability is still on the supplier, according to me.
Deepak, for this all order, the supplier is in all the times in a non-taxable territory, right?
Yeah, for this 14 section 14 purposes.
The whole of the order provisions is applicable to a non-taxable person in a non-taxable territory, right?
No, sir. If a order is in India, then 1312 says that the place of supply is the location of recipient, but order in India has to pay the tax on forward charge.
Right. So, which is who is an Indian person?
Correct.
Correct.
Correct. Supplier order is an Indian person. He will pay under forward charge.
Yeah, it would be under the forward charge.
Correct.
Now, point I'm trying to say is we are not looking at order in India. If that matter, order in India is everyone, like even all these OTTs are also now order services. It's like any other service that is provided.
Correct.
From the taxability, we are looking at the order who is not in India.
Correct.
Providing service to a non-taxable online recipient, which is like unregistered person.
Yes.
So the issue is someone in India providing services to an Indian is a taxable service.
Correct. But the provision, this says that order located in non-taxable territory. The 14 per se, order per se, overall can be in India, outside India. But 14 is narrowing it down, and it's saying that if a order is in a non-taxable territory, then 14 will apply.
Correct.
So from that perspective, now if the order provider, Google, is in US, okay, it is in a non-taxable territory, and it is received by me, I am not registered. Okay. In that scenario, it is clear that Google has to pay tax on this order services. Now coming to the next level, wherein Google has Google has a Play Store. Say there is a game, the app is there, and it is on the Google Play Store. Now, Google is an intermediary because it will satisfy these conditions.
Correct.
Now, should the tax be paid by the gaming app or Google?
No, no. So let's say you are an individual who have designed and developed the app. You are saying $10 per download installation, and you have uploaded that app in the Google Play Store console.
Right.
You are a person from, let's say, Australia.
Okay.
I am here in India downloading and buying that app, paying $10.
Correct.
In no way you are an order, because you are not the one who is providing the service to me. You are providing the service through Google Play Store. So for you, from the taxability perspective, for you, it would be deemed as if you are providing services to Google Play Store, even though it is downloaded directly from your server, the codes are coming from your server to me, all that is still happening. It is from your perspective, you person being in Australia, it is not an order service for you, it is the service that you are providing to Google Play Store.
No, sir, because I differ from that view, because Google is still a platform and they're transparent, because they say that the provider will be this gaming company in Australia, and if they satisfy these conditions, that they are not authorizing the delivery.
No, no.
I will
Google will be
authorize the
raising
delivery.
the invoice. Will you raise the invoice or Google?
Invoice will be raised by Google.
The invoice will be raised by the Google. Okay.
Yes. Okay. And it will say that I am charging you because you have downloaded this Australian game.
Correct. But it is, again, intermediary, the Google Play Store is involved in the supply.
So that's why they're clear in this, sir. The invoice is issued by the intermediary. In the supply, clearly identifies the service in question and the supplier in non-taxable territory. So they'll identify this game and they will identify the person, that is the Australian company also will be identified.
Yeah, it is identified.
Yes. So it will not become a intermediary in such case then. It will only mediate it, but it will not be an intermediary.
See, invoice is being raised by the Google. Delivery is done through Google.
Correct.
I don't know. I still feel that you will not be the order and the intermediary is Google Play Store.
Okay. Fine. We'll stick to that. Fine. But my question is little different. So even if you say Google is but are you saying Google is intermediary or Google is the order?
I am saying Google is the intermediary.
Correct. Google is the intermediary. Now my question is, if you have established that Google is intermediary, who will pay the tax on this? Will Google pay or the Australian company?
It would be the Google who is liable for it.
Correct. So where does this come from? Because it says an intermediary located in a non-taxable territory shall be deemed to be a recipient.
Correct.
But 14 says tax shall be payable by the supplier.
Correct.
So Australian company, I am the supplier, intermediary is the recipient. How can the tax be paid by the recipient when 14 says tax has to be paid by the supplier?
Agreed.
Who is liable to pay tax on OIDR services?
Supplier.
Section 14.
Supplier.
One. Yeah.
Supplier of
So
services shall be the person.
In proviso, it is only carving out an exception where there is an back-to-back arrangement between the supplier and intermediary and shifting the taxability on the intermediary, provided these conditions are satisfied. Otherwise, it will be, you will have to fall on subsection 1, and the supplier located in non-taxable territory would be liable to tax.
Correct, sir. But where is that coming from? Because if the intermediary they have defined, and intermediary is defined and intermediary is deemed to be a recipient, and the taxability is on the supplier.
Taxability is on the intermediary in proviso.
No, they have defined intermediary and they have not said intermediary will pay. They have only deeming him to be a recipient, and they have not told that, they have not further said that being a recipient, he shall be the person liable to pay the integrated tax.
Sir, I think intermediary is the person liable to pay if it comes under provision.
So that was the
exactly. That's
general
what we,
understanding.
Even BGM has a table showing that intermediary will be liable in such a case.
Correct, sir. Everywhere it is mentioned, but I didn't get where is that coming from. Exactly, that is my question.
As a recipient, will he now not become a supplier? I'm just thinking, okay, though it is not explicitly said.
If he says recipient, then I would say that there is no tax itself, because supplier also is in a non-taxable territory and recipient also is in a non-taxable territory. So there is no tax.
No, what I'm saying is, after assuming that he is a recipient, will he not be made a supplier now?
He should be made, but it is not made.
Yeah, it's specifically not said. That I get your point.
Because everywhere when we read the background or the reason of bringing intermediary, everywhere it is said that intermediary is brought in to make him taxable person or to make him the person who will pay the tax. But the proviso doesn't say anywhere that he shall be the person who is liable to pay tax.
Agreed.
Kuber sir, am I clear?
can you repeat once again?
See, what I'm trying to say is that intermediary generally is introduced here to say that if an intermediary is involved in this transaction, then what will be the role of intermediary is that he will be deemed as a recipient. Okay, he'll be deemed as a recipient. After that, what happens is not clearly mentioned in the proviso.
See, he will be deemed as recipient and will also be deemed as supplier when he also supplies to a person who non-taxable online recipient.
Where is that coming from?
Subsection 1 says the supplier of services is liable to tax.
Correct.
Correct.
Proviso is carving out an exception in case if there is an intermediary.
Right.
And if you read it along with subsection 1, intermediary will qualify as supplier of services who will be liable to pay tax.
Agreed, sir. Correct, sir. I think this sir has a point.
So, but intermediary, if you read this proviso, it says that in case of supply of order by any person located in a non-taxable territory and received by a non-taxable online recipient, and intermediary located in the non-taxable territory who arranges or facilitates the supply of such services shall be deemed to be a recipient.
Yes.
Recipient from whom? From the supplier in a non-taxable territory and supplying such service to a non-taxable online recipient, except when intermediary satisfy the following conditions. So they are saying that the intermediary shall be deemed to be a recipient only. So they have not said that he shall be deemed to be a supplier taking the shoes of the original supplier.
Deepak, you're stopping with shall be deemed to be the recipient, but it also goes ahead and says and supplying such services.
Correct. So recipient is supplying, but they have not coined the word that he will be a supplier.
No, and he is deemed to be supplying such services to non-taxable online recipient. The deeming provision is both for treating him as recipient as well as supplying the services to non-taxable online recipient.
Correct, madam. When they've used the word recipient and they're saying just supplying and they've not used the word supplier, there my difference comes in because they've not said that he is a supplier. That's why I'm saying there is a gap here.
No, if you are regarded, if you are deemed to be supplying such services, then you are the supplier.
So Deepak sir, see when the person in non-taxable territory supplies services to a NTOR in India is covered by provisions of subsection 1. Now, proviso carves out an exception saying if it is supplied to an intermediary in non-taxable territory, then that intermediary shall be the recipient. That part is clarified only in the section. Again, while determining the POS for the service supplied by the intermediary to the NTOR in India, you have to again go and see provisions of subsection 1, wherein it says then intermediary will be the supplier of service and intermediary will be liable to pay tax. That is my understanding. Second limb is not clearly spelled out, but we have to again look at the transaction and see where for POS for the service supplied by intermediary to the NTOR in India.
Okay.
Is that correct?
No, I'm not convinced.
Okay.
But we'll park this. Shall we go to the next issue?
Yes.
Next is when a registered person is receiving for non-taxable reason. Okay. So when a registered person, he is receiving it for a non-taxable reason, not non-taxable person. Now, I am a registered person. I am availing some online games from Google and I am using it for personal purpose. So in that case, still should a receiver pay tax under reverse charge?
Come again once again.
Reverse charge is applicable on a registered person. Now, registered person has bought some services, but he is using it for his personal use.
Right.
Will reverse charge be payable or no?
No.
But he's a registered person.
No. So the moment let's say Deepak P. Jain has a proprietary registration and Deepak under his personal capacity also buys or consumes something. Okay, let's say you are shifting the house and you have hired a service of GTA or you have taken one lawyer in individual name. Why would that call for a reverse charge liability?
So for renting services, they have made this distinction, saying that if you are taking this renting services, even if a proprietor for a non-business, there they have specifically distinguished. But other than renting services, they have not made this distinction. And non-taxable online recipient says that any unregistered person. Non-taxable online recipient means any unregistered person receiving OIDER services.
I would still say you are an unregistered person taking OIDER services and OIDER has to pay tax on it.
Yeah. There could be both the views. Department will come back to the recipient saying that since you are registered, because it is easier for them practically to identify a person in India. But I also agree with you saying that the supplier has to pay it because the recipient is not using it for his business, he's using it for his personal use. But there could be a prone that recipient will be questioned because it is just ease of access, nothing else.
Right.
The next question is from a order supplier. Now, if the supplier is supplying the services, how will he know whether the recipient is registered or unregistered? Because
today, every order where I am seeing is they're asking that are you a registered business?
Correct.
Give the details. I think they would specifically ask this question and take a call accordingly.
The profile registration, when it happens, that time we'll have to give basic email ID and phone numbers and things, and that time they ask.
Yeah, and they are, if you are registered, they are not charging GST. If you are non-registered, they are charging GST.
Correct. So in one instance, what I've seen is I've used this Dropbox and they had charged GST. Later on, when I went and said them I'm registered, I gave my GST number, they reversed their charge also. So that is the way order collects the information and they determine whether it is to be taxed or not taxed. Next issue is you have a live streaming where the content can be downloaded, and another option is content is live streamed, which means there is a person who is involved behind the screen and he's, say, taking a class. You have online lectures and the person is delivering it live. You cannot download it. So in case of live streaming, there is a human intervention. So in that case, will we tell that since human intervention is involved, it is not OIDR services, or still we will call it as a OIDR services?
Still order because a limited human intervention.
So you are saying that there is a limited human intervention, but the definition has deleted human intervention. So even if, so what do we mean when they have removed involving you minimum human intervention was permitted prior to the amendment. Now amendment has removed essentially automated and involving human intervention. Will your answer change now?
Yeah, so this, they made it broad. So because that minimal cannot be defined. With this elimination, the definition has become broader and it did not become narrow in my view. So it doesn't really matter whether human intervention is heavy or minimal. Nature per se is delivered over electronic media. That is more important. Even if the whole of the delivery supervision is required, doesn't really matter.
Okay. So deletion of minimal human intervention doesn't mean zero human intervention.
Yeah, it can be maximum human intervention also. Unless Kuber has another view.
Correct, it's expanding the scope.
So any service wherein even if a human intervention is there, the delivery should happen through a information technology. If that is satisfied, then it becomes a order services. Okay, but when the again we have to again come back when the content is downloaded and not available, or when the content is downloaded can be viewed offline, there we'll have to read the definition and I'll have to come back on, does information technology mean that if it is downloaded on the computer or downloaded on any device, it is available still? Will it be treated as a OIDER or no? But essentially, whenever this content we download, like when we download anything on the Audible, Audible, we download any ebook and it can be heard on the go. This downloaded information actually is not permanent for us, even though they take subscription and they say 1 credit is available. The fact is that after after a couple of months, if you are not subscribed to it, right, the information may not be available to you. And the content can be removed by the supplier or the provider of this service. The reason why I'm saying this is that when I read the terms of the Audible user service, I'll just share that. It says that this information, as a convenience to you, we may continue to make your purchased content available for re-download through the service account, but we do not guarantee that such content will be available for re-download, and Audible will not be liable to you if it becomes unavailable for further re-download. So whatever we assume that we are paying some subscription and we are downloading it, it will be available in the device later on, may not be available. It can get erased, could be for various reasons that the original supplier has not given the right to this intermediary, or any reason, because they have not spelled out what could be the reason. That it could be based on some time constraint also, saying that, okay, we will give the downloaded content to you for 6 months. After that, we will erase it. That is possible. Same thing is there with Google Play Store also. They also have a kind of similar tone, but in a different wording, saying that information will be available to you, and we have a right saying that we are not guaranteeing that this content will be available to you. E-learning courses we have discussed, electronic provision of ebooks we have discussed, online database and access to digital libraries. This is the OIDER services similar to our any subscriptions what we take. Their information will be available only when we log in. So that's the OIDER services. And determining whether a person is a non-taxable online recipient or not from supplier's perspective, like we have discussed, it is based on information which the OIDER collects it. But if the OIDER doesn't collect that information, okay, now most of them are collecting, but in case they do not collect whether the recipient is registered or no, in such case, the OIDER will be liable to pay, because government will assume that the OIDER is providing to non-taxable online recipient, and the supplier will have to pay the tax on that. So that is it. Any questions in any of those issues which we were discussing?
Deepak,
Yes, sir.
what's the non-compliance of it? Like Dropbox, if they have not complied, what would happen?
See, this simplified registration under 14, what they've said that OIDER has to appoint a person in India and get it registered.
Firstly, is there anything notified under that scheme?
No, not yet, sir.
Nothing is notified.
Nothing.
Technically, 14.2 is irrelevant because there is no notification issued under 14.2.
Correct.
Yeah. Now, that being the case, how will like Dropbox is someone who is a seasoned player? Imagine that your own example of that Australia you hosted on Google Play Store. Now you also allowed people to come to your website and subscribe the product. You have entered the payment credit, you have integrated some PayPal credit card, whatever.
Right.
And they are doing this. How will Government of India catch it?
So this RBI payments when we make earlier without OTP we could do that annual subscription and everything used to go. At least now that RBI have stopped saying that any authentication or any payment should be authenticated.
Right.
So that is the only information I think government has to find out who is the person who is providing this services.
In fact, this Chat GPT, which is charging $20,
they
are not giving me a bill which is saying GST included.
Correct. They're only giving a receipt.
They're only giving a receipt.
Right.
There are a lot of websites which is where I am paying using credit card every month. I don't have any GST details. Like I pay to Postmark, I pay to lot other things. It's just that I load that into my business, I pay RCM. I don't know how they are complying.
And no circular or any clarification as such saying that what.
My worry is the converse. You are an exporter of service. You have no clue about the local laws there. Like that example which Madam Dhanashree was asking about the import of services, where we are saying we are paying. Converse, let's say I am clear tax. Someone, a foreign national, coming to my website using my service. I am providing order and I am treating this as export of services. I am not paying any digital tax of US.
Correct.
So that is also an open area.
Yes. So if you do not know, then from an Indian perspective, you will treat it as an export.
Correct.
But from that other country's perspective, you are non-compliant.
Yeah. I don't know whether if it was a converse, it is clear order, but I am not paying any order tax.
Correct. There's no clarity definitely on this.
Yeah. Any other questions, views, members? Especially when Jatin sir is not there, you should open your mouth and ask if you have any question or no question answer or anything. I'm sure you're worried when Jatin sir is around.
In other countries, like India only is lenient, or other countries are smart, no? Like I don't think any other country will leave bit of tax. So how are they allowing? What is a general practice?
Say, madam, that India is lenient and others are not.
No, because I don't see anybody paying these kind of taxes. No, we are this OADR itself we are discussing only after service tax, like only in the recent times, no? Likewise, there are so many.
There is service tax also, and in other countries there is digital tax, madam. They don't call it as OIDR; they call it as digital tax, and they are all on subscription model, most of them. So they do have country-specific tax. They don't mention the tax; they just mention tax, and we pay it off. You download any online services, there'll be a tax component. Digital taxation is prevalent. When I was reading this, I saw that there are a lot of countries who are levying digital tax. They call it a different name. Here we call it as a bigger term. That's it.
Probably from RBI, you have to find out at policy level what is it happening, how much is the collection, how are they planning for increasing the tax collection, something like that.
At least for goods, there is a WTO which says that tariff cannot be things like that. But for digital thing, there is no consensus which is arrived. So every country is levying because there is no consensus arrived saying that there should not be any tax on digital transactions. Similarly, is this equalization levy. No, this is also on online advertisement, any e-commerce transactions. You are paying equalization levy.
So I think generally and like practically what has happened wherever government has caught hold of the foreign exporters to India, wherever they've caught hold of these OIDR, they have sort of registered, they're now paying taxes. But the new, and there are so many SaaS and the new companies coming in now because of AI and otherwise, whoever they are importing, exporting to India, they are like rightly, like Venu said, they're just giving a receipt or they're not even giving anything for the payments. They are still not caught by the government. And there is definitely some scope for tax, and taxes definitely getting escaped. As long as the Indian company is paying tax, the Indian company, then Indian business people or companies are getting
ITC that levy.
safeguarded. Yeah, and we are getting the credits. But how will if the government, for example, catches hold of tax ChatGPT, they will not know how much of business B2B, B2C. They don't have any tracking of that. So there was one instance where we had got this as a case. The customer was an OIDR, like our client was an OIDR. They'd got a notice, and that's when they came saying, okay, this much is B2B, this much is B2C. Most of it is, B2B, so we don't have to pay tax. And now the small percentage is B2C, we will go ahead and pay tax. That's how we arrived at that conclusion. But in many cases, the businesses may not even have the tracking of that.
So in your case, Dhanashree, is like, have they exposed their full books of accounts? Like they should allocate, this is the revenue pertaining from India, right?
Correct. So they are saying out of this, like this is the revenue pertaining to India. We've not, of course, told this is my overall revenue from all over the world. We have not told all of that. We've just told, okay, this much is the revenue from India because we are able to track the transaction based on this one IP address, etc., etc. And from this much in India, only this much is B2B, and we were okay to pay tax on these. The rest of it is B2C, so it is not our liability.
No, it's converse, no? Only B2C is their liability. B2B is not their liability.
Yes, correct. Yes.
Even if they say 50% lie also, you have no clue about it.
Correct.
And so your office was registered office for their behalf?
No. When we were registering, this was some time back, 3-4 years back. So when we were registering under the GST law, I think I'm not able to recall what did we give as registered address.
Yeah, because someone would have been nominated as a...
Correct. Maybe it was our office only. I'm not able to recall exactly now, but I think maybe it was our office that we gave it as a registered address.
Okay. Deepak, who will answer the questions, unanswered questions?
On information technology, I'll come back.
Yeah, information technology definitely will come back. But the macro questions.
Who will pay the taxes and whether
how will this be monitored? And Sujata Madam's question, India is a lenient country, others are not lenient.
We could restrict to taxation whichever information is available. Macro questions, I'm not sure if we can answer at this forum.
No, but still I'm just thinking, whom do we at least raise these questions?
So for OIDR, Bangalore is the place where OIDARs
West Commission.
from across the world sort of register. So the Bangalore guys are pretty good. If we want to answer certain, they will also not know many answers, but certain questions we can ask them. Maybe we can give a representation and they can put it up as an FAQ or something like that. As a forum of people who are reading the law, maybe we can do something like that.
Yeah, maybe we should ask, like, what is your view, how it works?
Yeah.
What are you doing? So maybe we can have them say all of those things.
Yeah.
If you have a connection, why don't you establish and see?
Yeah, I'll look into it.
Yeah.
Maybe I'll coordinate with some of you and we can figure a way to do this.
Done.
Deepak, maybe you can put together all the issues.
Sure.
Then we can all discuss together and write a letter to them saying these are all our queries. Would you have any answer to it or something?
Sure, fine. I can put up a letter.
And one aspect of discussion, actually FKCCI wants a couple of issues to be raised. So could we, as if we have any of the present issues which we can compile and give it, that is what they have asked for. That has been called for by the commissioner. So maybe it can be classified into 2 or 3 categories where it is more of the GST council related discussions and from the state per se, if we want some procedural aspects to be looked at, and any unanswered questions like this also could be taken up. Maybe we can look at it. And we can take it forward.
Sure. Okay, I think we'll call for the day. Thank you so much, Deepak.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you,
Thank you all.
everyone.
Annapurna, next session is yours.
What is the
Thank you.
topic?
Bye.
Approaches and outcome in department proceedings.
Yeah, sure.
Okay.